judgment today in a case challenging the control of leadership in Parliament. Justices John Chigiti, Lawrence Mugambi and Jairus Nga are set to render the judgment. The case was filed in 2023 by 12 individuals who identified themselves as registered voters. They contended that 171 members of the National Assembly were elected on the tickets of political parties that formed the Azimio coalition, while 156 members of the National Assembly were elected on Kenya Kwanza coalition parties' tickets. Let's listen in to part of the judgment.
Of association and Article 36 of the Constitution and, quote, migrated to the Kenya Kwanza coalition, to the Kenya Kwanza alliance, both in writing and in action, close of quote. The Speaker held that the parties have, in quote, signed and deposited with the registrar, close of quote, coalition agreements. 5. The UDM, PAA, MCCP, and MDG had raised objections or filed petitions in this honorable court contesting their membership in the Azimio coalition. Now it is worth noting that the Speaker, having been sued in this petition as the third and the fourth respondents, apparently in his official capacity and private capacities, respectively, swore and filed a replying affidavit dated 23rd November 2023 in response to the petition. Nowhere in that affidavit has the Speaker alluded to or provided any evidence of the existence of any post-election coalition agreements involving UDM, PAA, MCCP, MDG, and Kenya Kwanza alliance. There is simply no evidence of any post-election coalition signed and deposited with the registrar of political parties as alleged by the Honorable Speaker or at all. As a matter of fact, none of the rest of the respondents, including Honorable Ichungwa, who is said to have tabled the post-election coalition agreements in Parliament during the debate on the issue of the majority and the minority party in the House, has exhibited any such agreement. According to Section 9(1) of the Political Parties Act, the Constitution or the rules of every political party shall provide for all the matters specified in the second schedule of this Act. One of the matters specified in the second schedule of this is a requirement that the Constitution or the rules of a political party must provide rules for entering into, particularly Rule 21 of the Schedule 2 to the Act. It has not been demonstrated, at the very least, that any of the parties alleged to have entered into a post-election coalition agreement with Kenya Kwanza took any step in compliance with this particular rule, enter into a coalition agreement with Kenya Kwanza. In the absence of any proof of post-election coalition agreements entered into between UDM, PAA, MCCP, and MDG, and the Kenya Kwanza alliance, the Speaker cannot be heard to fault the registrar of political parties for not producing them. She could not produce what had not been deposited at the registrar of political parties. If it is true the UDM, PAA, MCCP, and MDG political parties had signed and deposited the agreements with the registrar of political parties, we are entitled to assume that they must have had in their possession copies of these agreements.
We will be bringing you more of the judgment updates in our oncoming bulletin.